Tech Reimagined. Redefining the relationship between people and technology. Brought to you by Endava. This is Tech Reimagined.
Hello, I'm Bradley Howard and I'm happy to welcome you back to the latest episode of Tech Reimagined. It's my pleasure to introduce you to our guest today, John Byers, who's a partner and commercial solicitor at Osborne Clarke. Hello, John. How are you today?
I'm fine, thanks, Bradley. Thanks very much for having me.
So the topic of today's episode is AI, that's artificial intelligence, from a legal perspective. So, John, can you tell us a bit more about yourself and your background and artificial intelligence as well?
As you've mentioned, I'm a partner at Osborne Clarke, which is an international law firm, and I've been in the IT industry as a lawyer for more years than I care to remember. I started off as an outsourcing lawyer, working on traditional outsourcing deals, then moved progressively more and more into digital technologies. And actually, it was the evolution of the outsourcing industry itself which kind of pulled me into artificial intelligence, and it's an absolutely fascinating topic. And the upshot is that I now lead the international team at Osborne Clarke that advises on artificial intelligence and machine learning. I'm also in an organisation called the International Technology Law Association as a board member, and I'm also responsible for their AI committee. And I've written a book on the legal implications of artificial intelligence, which is now in its second edition. So I'll have to get a second edition to you as well. And there's a third edition in the pipeline. And with my iTech law hat on, we've also published a comprehensive guide to machine learning and artificial intelligence ethics. So, yeah, that's me, really.
Well, thank you very much, John. And it's amazing to have such an expert on the show today. Typically, when people think of AI, they think of something out of a science fiction movie. But of course, it's completely in our day-to-day lives through navigation apps or ride sharing, video apps that recommend the next video, or email spam filters. The list just goes on and on. So it makes sense, of course, that there should be a legal aspect to it, which you were discussing in your introduction as well. So can you just walk us through some of the legal issues that software developers might need to think about when they're developing AI platforms?
Yeah, sure, I'll do that. And it probably makes sense for me to just give a brief overview of the different types of AI technologies, because I think there's a lot of confusion in the market about what artificial intelligence actually is, and a lot of frankly ill-informed journalistic hyperbole. I don't want to do my kind of journalist colleagues down, but it's quite a catchy strapline to talk about artificial intelligence and machine learning, and inevitably you end up with, as you've been intimating, one of two binary outcomes. Either it's the end of the world with the dystopian robots, or the beginning of the future where AI is going to save us from mutually assured destruction. I think the reality, as you've indicated, is somewhat more prosaic. It's quite an exciting technology, but it's very specifically directed. And we're nowhere near what some commentators have called the singularity, which is when machines become self-aware. I think what we have now is a situation where we've got some very, very clever, specifically directed applications. And let me kind of unpeel the onion. And if the listeners can kind of have a metaphorical onion in their head when I'm talking about it, the way I kind of visualize artificial intelligence is you have the outer layer, which is AI, which is the ensemble term, which covers a variety of different technologies, some of which are a black box, and we'll get to that in a minute, and some of which are not. So you might have something called a decision tree, which is an assistive AI technology, which is essentially, you can conceptualize that as an automated yes/no flowchart. So that would help an AI solution. And underneath the AI layer, you've got machine learning, and that's the really exciting area that all of these legal issues stem from. And this is not a new technology. This was something that was conceptualized back in 1952 by a chap called Marvin Minsky, who wrote about it with another guy called Seymour Papert. And they just didn't have the technology infrastructure or the scale of computing power to actually make it useful. And that's where the neural network sits, which is a form of artificial intelligence that seeks to mimic the way the human brain works. And finally, within the machine learning layer, right at the very core of the onion, is where the really exciting stuff is, which is deep neural networks. And these are machine learning neural networks that are scaled up using the power of modern technology. And this is really where the kind of secret source of machine learning actually is. So that's a kind of explanation of the different types of technology that together come to form artificial intelligence. And in terms of why it's different and how it's different from traditional computing systems, it's probably worthwhile me explaining that we're all aware and illustrating the issue that causes a lot of the downstream legal problems. But we're all aware that a traditional computer system is essentially a computer that operates a prescriptive program and it spits out a defined solution, and that is something that we've been very used to for the last 60 or 70 years. That's traditional computing. You have a human operator that types a program, produces a result. Very good at lots and lots of routine transactions, not very good at independent decision-making or coming to its own conclusions. It's a very unforgiving environment. If you get the computer program wrong, it will spit out a syntax error. Contrast that with a machine learning situation and a machine learning solution. What actually happens there is that you have a problem and you assemble a data set, a collection of data that is used to train a machine learning system to come up with a solution to the problem. So there is an algorithm which defines the way in which the machine learning system reviews that data, but you're not writing a prescriptive program for it. It's coming to its own conclusions. And therein lies the problem, because what happens is a machine learning system will come up with an answer which will be on a variable scale. So just as you, Bradley, if you make a decision in relation to something, you're going to come to a conclusion on a range of probabilities. A machine learning solution will do exactly the same thing. And the important point to note is that these decisions at the margins of a probability curve, and what the technologists call edge case decisions, they're not faults. They are within the bounds of probability. They're just less usual. And this causes no end of problems for lawyers, because we're used to very clear concepts of cause and effect. We like to know who is responsible for a problem. And the law is geared up in that way to provide a remedy to someone who's been harmed. If you can't identify a particular fault, then you can't serve justice or provide a remedy to a person that's been injured. And that's fundamentally at the heart of machine learning. And I ought to kind of elaborate in that there's not only the kind of edge case decision problem, which is the kind of variable solution issue, which taxes lawyers, but also at the heart of neural networks, we have a fundamental technological conundrum, which is that they're black box solutions. So I alluded to that earlier in my answer. And what that means is that even though data scientists can create the algorithms within which these systems operate, they simply don't understand how or why the machine learning system, particularly in the context of deep neural networks that have lots and lots of processing layers, come to the conclusion they did in a particular circumstance. It's not explainable. And that causes all sorts of issues, and it compounds the causation issue that I've just discussed in terms of determining who is responsible for a fault. So that's a fundamental break point in relation to serving a remedy up for someone who's been harmed.
So when someone comes up with an original idea, at what point would you like to be engaged?
The answer is that we need to be involved as soon as possible, recognizing that lawyers cost money. But I think we do need to educate the client to a certain degree on the particular parts of their solution that will cause legal issues. So we talked about the causation issue with the use of neural networks, and that's really not something that can be remedied particularly well. It's a feature of the technology. So I guess if you're you're a client that's about to use a machine learning solution, and we're going to get to regulation later, but if you're about to use a machine learning solution, you need to ask yourself whether it is worth the inevitable regulatory risk to employ something like artificial intelligence, or whether it can be dealt with by a more prosaic technology, a more conventional technology. And that's certainly a decision gate that lots of businesses are going through at the moment. What you simply can't do is implement artificial intelligence because it's the next bright, shiny thing and it will do it. There are regulatory hurdles that we'll talk about in a minute, which will cause you to pause and think, and pitfalls that you can fall into. As a developer, one of the other issues that you need to bear in mind is, well, there are loads, but let's start with bias and how machine learning solutions can inadvertently create bias in outputs. This is to do with how you select your data sets to train the machine learning systems. And one of the most interesting examples that I've come across, which really brought the whole issue to light to me, was listening to the head of Google Translate, who was talking about how Google developed their Translate algorithm, which is has one of the largest data sets on the planet, actually, as you can imagine, but it's taking in all sorts of data sources around the world to create a multi-language translation platform. And what Google found when they deployed Google Translate was that the algorithm inadvertently conveyed the prejudices of the texts that it had been reviewing, and Google had given it lots and lots of texts that were out of copyright, very old texts like the Bible, and these outmoded cultural positions were reflecting its outputs. And there's a very interesting example of it, Google Translate taking English and translating it into Finnish and then back into English, and likewise with Turkish, which are less, I'm not an expert in Finnish or Turkish, but then they're less gender specific. So if you said he is a nurse, Google Translate would come back with she is a nurse. If you said or typed in she is a doctor, it would come back with he is a doctor. If you said he is lazy, it would come back with she is lazy. So clearly completely unacceptable from the point of view of Google to actually have that kind of inbuilt stereotyping and outmoded cultural attitudes. And what Google had to do ultimately was to create another machine learning system to arbitrate the decisions of Google Translate so that it could produce alternatives if there was bias that was demonstrated in the output.
I think there was another example with when Apple launched their payment card with Goldman Sachs. The spending limit was higher for some men than it was for their spouses, for example. I think there were a few high-profile cases on that. But Apple turned around and said, well, there is no bias in this. You know, we've just let the AI algorithm choose what the spending limit should be. So it had inadvertently come up with that.
Yes, no, I mean, I think you've hit the nail on the head there, Bradley, because actually what people assume that lack of bias is the application of objectivity to a decision-making process. They couldn't be further from the truth. Actually, what a lack of bias is the application of subjectively applied societal norms.
Yes. Yeah.
And so it's a lack of bias can be very subjectively targeted, and that's what makes it so hard to resolve. And the other example is the Microsoft Tay bot that was launched. And I don't know whether you're aware of that one, but Microsoft launched Tay a few years ago into the bulletin boards and the chat boards. And it was intended to interact with users. And of course, it became racist, misogynistic, far-right sympathizer, and deeply offensive. And it was simply a reflection of the demographic on those chat boards. So it was a reflection back of society, and Microsoft had to pull the plug on that because it was not acceptable to have a machine behaving in that way, and that's what makes it incredibly difficult to manage.
So how do you manage that from a legal perspective?
Well, there are a number of ways you can manage that from a legal perspective, and I think you need to look at the way in which data are sourced for machine learning solutions. Data sets are sourced for machine learning solutions. I guess we're still at the latter end of what I call the Wild West phase in terms of this technology. And the position is compounded somewhat by the fact that we have a lot of very exciting startups that are looking for immediate return on the market and looking for investment. And that, I think, encourages less than precise decision making in terms of what the the sources are that they use where they get their data from. And the first point is that they need to apply appropriate due diligence in relation to that, and they need to make certain that the data that they're sourcing from is suitably representative of the demographic of the problem that they're going to be solving with their machine learning solution. And they shouldn't just be licensing it in wholesale from third-party dataset providers. This is a problem that lots of businesses have found with licensing in facial recognition databases, for example, because they've clearly been compiled as a result of a university study. So all they contain is lots of white Caucasian faces, and they're not designed for use in the real world. And the fact that they're looking for a quick return on their investment means that they take a kind of quick decision to use that, and it ends up backfiring because the application that uses the facial recognition isn't as efficient as it would be if it had better data.
Yeah, it's when big data needs to be bigger.
Exactly right. Yeah. No, that's right, and that kind of leads into another major issue with machine learning, and that's on the intellectual property side and the licensing side. And clearly, you've got to license in data sets correctly to make certain they're representative and demographic and not biased. So there are all those licensing issues, but there are also sort of conceptual issues with intellectual property in that we talked about a trained machine learning system and a machine learning system that isn't trained. And the problem with current intellectual property law is that it doesn't allow you to protect the trained element of a machine learning system effectively. You've got copyright law, which covers, and I'm oversimplifying this dramatically here, but you've got copyright law, which covers the kind of authorship and the things that are capable of, typically it might be pieces of software, and then you've got patents, which typically deal with the underlying technology and the hardware. And the delta, where the value is in these machine learning systems, is in the trained element. So you could have a trained system and an untrained system, and for the purposes of copyright law and the patent law, is exactly the same. They've both got software and they've both got hardware. The only difference is the algorithm's not been trained. So the only way that can be protected effectively at the moment is through trade secrets. So you've got to keep that information secret. And that's a big problem for investors in these types of businesses.
What are the main differences between European, UK and US approaches to AI regulation and law? We have listeners from right across the geographies. So can you just summarise what the differences are, please?
We're still in a process of evolution, Bradley, when it comes to regulation, and the three jurisdictions are taking very different approaches. And I would summarise let's start with the US. So the US is very much a mixed bag and it's a composite of state-related laws and there's an evolving federal jurisdiction. The state-related laws tend to be focused around the collection of biometric information. So that's information relating to you as a person, as an identifiable person. So there are some quite strict laws in relation to biometric data collection in Illinois, for example, and a few other states. But on top of that, you have an evolving jurisdiction which is being managed by the FTC, the Federal Trade Commission, which is, I think, quite admirably taking it upon itself to look at AI systems, and it has a broad jurisdiction under the FTC Act to stop misleading or deceptive trade practices within the US. And very interestingly, quite recently, it took a business called Ever to task, and Ever are the publishers of something called Ever Album, which I think is I haven't looked at it, but I think it was a kind of database or an AI solution with facial recognition data in it. And Ever made a commitment to its customers that they would delete the data their facial data if they asked for it, and in fact they didn't. So they were misleading their consumers. And the FTC essentially told them to unwind and untrain their machine learning system and delete the personal data that had been unlawfully used within the algorithm, which is quite a dramatic remedy. And in fact, it's a remedy that goes beyond what is available currently in the UK and Europe at the moment. They did come to a settlement, but they were actually forced to unwind their machine learning algorithm as a result of that. So that's what's happening in the United States. European Union has the Draft AI Act, which is intended to regulate and prohibit some types of AI systems and regulate what they call high-risk systems. And these typically tend to be, and I won't go into detail, systems which could cause you damage or injury if they go wrong. So obviously automated cars will be covered by that. But there are also categories for systems that make decisions about whether or not you're eligible for financial services or products or insurance, or systems that are controlling pollution within the European Union, so that you get a sense for the types of systems that are regulated. And that law piggybacks itself on the European product safety regime and forces providers to actually go through a lot of compliance steps to ensure that they are compliant with the regulations. And obviously that is under review at the moment. What is very interesting about that particular law is, although it's admirable that the EU is taking a top-down view of regulation, it's not giving users any rights really substantively to seek redress as a result of breach of those rights, which I think is a relatively peculiar decision on the part of the European Union, because I think if you're going to put in place a big law that regulates AI, you want to give people the right to seek redress if they're harmed as a result of that AI.
Like they have with GDPR and other data laws.
Yes, exactly. And, we come back to Article 22 of the GDPR, which is the automated decision-making part of the GDPR, which I think is actually very interestingly drafted, and actually I think would serve as a really nice core for a European law on AI, because that looks at the output. It looks at whether or not there have been any legal effects on the user as a result of the AI decision making, or any kind of what the GDPR calls similarly significant effects, and gives them a remedy as a result of that if they're harmed. So I count that as a bit of a missed opportunity. And I've got, for the listeners that are interested, we've got iTech Law is just about to publish a green paper on the European law, where we go into the nth amount of detail about where we think these are problems. But I'm not going to go into detail now on that. But that's my impression on the European position, which is very bold and innovative, but I think misses a trick a bit. And then finally, you've got good old UK, which is sitting between the US and Europe in a post-Brexit environment. And I think the likelihood that the UK is going to go down the track of implementing the AIA is minimal. I also sit on the all-party parliamentary group for artificial intelligence with members of the House of Lords and House of Commons as an advisory board expert, and their view is that we're going to take a sector-led approach. So we're going to look at different industries. We're going to look at things like financial services, we'll look at competition law, we'll look at intellectual property law, and rely on existing laws such as, for example, the Equality Act, which would pick up things like bias in AI. But we're not going to go down the track, at least at the moment, we're not going to go down the track of having a top-down law in relation to the regulation of artificial intelligence.
Right. Okay. Well, thank you very much. That was very comprehensive. It's been great to have you on Tech Reimagine and answer some of the big questions around artificial intelligence from a legal perspective. To all of our listeners, I hope you enjoyed today's episode of Tech Reimagined, and thank you for joining. Please show us some love and hit that subscribe button if you like the episode. And don't forget to let your friends and colleagues know about the show. If you have any questions or you want to reach out, please drop us a line at endava.com or use the @endava handle on pretty much any of the social media platforms. We look forward to hearing from you. Until next time.